In October 2025, the Court of Appeal for Ontario delivered a landmark decision that fundamentally changes how a court-ordered receivership sale works in Ontario. As Brandon describes in his blog, this is not unique to Ontario, and the case answered a critical question that haunts receivers, creditors, and buyers. Can a judge reject a perfectly executed receivership sale simply because someone offers substantially more money at the last minute? The answer, according to Ontario's highest court, is a resounding yes. My name is Ira Smith. Well, it's not really Ira Smith, but it sort of is. President of Ira Smith Trustee and Receiver, Inc. Both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So shoot us a message, give us a phone call. We would love to speak with you. I hope you can watch the rest of this video and find the information helpful.
Today, we are diving deep into a single court case that has, no joke, completely upended the rules for court-ordered sales right across Canada. We're going to look at how one shocking decision kicked off a whole new era in insolvency law, an era where the final price tag can actually blow up a perfect by-the-book process. So let's get into it. Okay, just picture this for a second. A receiver runs an absolutely flawless sales process for a property. I mean, textbook perfect. They find a great buyer, they negotiate in good faith, they shake hands on a solid deal, and all that's left is to get the judge's final okay. Everything's lined up. But then, literally at the 11th hour, someone else waltzes in with a much, much bigger pile of cash. So, here's the million-dollar question. Can a judge really just toss out that perfect deal and chase the bigger offer? And the answer, coming straight from Ontario's highest court, is a huge, unambiguous yes. And you better believe that one little word sent massive shockwaves through the entire commercial and insolvency world. It's a total game changer for creditors, business owners, and buyers. So, what is this case that caused all the commotion? Well, it's a decision that, frankly, anyone involved in insolvency in Canada now needs to know inside and out. The case is Cameron Stevens versus Conacher Kingston Holdings. It's a 2025 ruling that basically set a new pecking order. What the court decided is that the number one goal, getting the absolute most money possible for the people who are owed, the creditors, that goal can actually override the need to protect a perfectly run sales process, especially when a last-minute bid comes in that's a whopping 37% higher. To really get why this is such a big deal, you have to hear the story behind it. It all starts with a process that was, by every single measure, perfect, and it ends with a last-minute bombshell that just changed everything. You know, what's so wild about this case is just how perfect the initial sales process was. The court-appointed receiver, they did everything right. We're talking an 8-month professional marketing campaign. They got multiple offers. They negotiated in good faith. They had a deal locked in that just needed the judge's rubber stamp. Even the judge himself called the process unassailable. Unassailable. That means it was flawless. You couldn't find a single thing wrong with it. It was the gold standard. But then, the bombshell. Right before the court hearing, a new bidder pops up. And they didn't just make one offer. Oh no. This timeline shows you how the pressure just kept building. First, an offer that was 6.7% higher. Okay. Then another one, 14.2% higher. And finally, right before the hearing, a mind-blowing offer, 37% higher than the deal that was on the table. So let's translate that 37% into real money. We're not talking about a few extra bucks here. We are talking about $3.5 million. An extra $3.5 million that could go straight into the pockets of the creditors. You can see how that single number just changed the entire conversation. So you can imagine the judge. He's stuck between a rock and a hard place, right? He's got these two massive competing principles. On one hand, you got to protect the integrity of the process. I mean, the receiver did a perfect job. The buyer was acting in good faith. If you throw that all out, you could create, quote, chaos in the commercial world. But on the other hand, how on earth do you just ignore an extra $3.5 million for the creditors? To approve the lower offer could be seen as improvident, which is just a fancy legal way of saying it's a bad and harmful decision. What do you do? Well, what the judge decided to do, and what the appeal court confirmed, didn't just solve this one problem. It basically created a whole new rule book for how these sales get handled from now on. And this is where it gets really smart. Instead of just picking a side, the judge came up with this really creative, elegant solution. He didn't just take the late bid. No, he reopened the bidding process for 6 more days. He invited both the original buyer and the new guy to the table to submit their best offers. And this part is key. He protected the original buyer. He ordered that if they ended up losing, their legal costs would be covered. It was a really brilliant way to balance fairness with getting the most money.
Now, the original buyer, they weren't happy. They appealed, but the Court of Appeal for Ontario shut them down flat. And in doing so, they gave us this quote, which is now everything. The paramount objective is to maximize recovery for creditors. That right there is the new North Star. Everything else, even a perfect process, comes second. So let's break down what we learned from this appeal. First, a huge price difference, like that 37%, is reason enough for a judge to step in, period. Second, that old legal test people used, the sound air factors, well, that's now more of a flexible guideline, not some rigid checklist you have to follow. Third, like we just saw, getting the most money for creditors is priority number 1. And finally, it confirmed that judges have a lot of power to get creative and find solutions that fit the situation.
Now, you might be sitting there thinking, okay, that's just an Ontario thing, right? Wrong. The Cameron-Stevens decision is actually part of a much bigger trend that's happening all across Canada. Courts from coast to coast are adopting this exact same creditor-first mindset. And you can see it playing out clear as day in British Columbia. Take the Vicente Hotel case. A judge held a live auction right there in the courtroom. And get this, it resulted in an extra $3.5 million for creditors. Sound familiar? In the Willoughby case, the court called a sale into question because the process felt rushed and the price gap was huge. And in Peak Hill, the court greenlit a creative, tax-saving deal that, you guessed it, added about $3.5 million to the creditor's pot. The pattern is impossible to ignore. All right, so we've been deep in the legal weeds, but what does all of this actually mean for you? Because whether you're a creditor, a business owner, or somebody thinking about buying assets out of a receivership, these rulings have very real, very practical consequences. If you're a creditor, listen up, because this is fantastic news for you. The courts are now basically your biggest champions for getting the most money back possible. You have really solid legal ground now to challenge a sale that seems too low, especially if a late offer shows up that's more than 30% higher. The big takeaway for you? You have to watch these sales processes like a hawk, and you need to speak up if something doesn't feel right. Now, if you're a business owner or you've signed a personal guarantee, this is kind of a double-edged sword. The good news is, this push for higher sale prices could actually reduce the amount of money you're personally on the hook for. It's a huge reminder that the sale isn't final till the judge says it's final. The absolute key here is to get professional advice and get it early so you know all your options. And finally, if you're a buyer looking for a deal, well, the game has completely changed. Getting your offer accepted is no longer the finish line. It's not a guarantee. The new strategy has to be bidding your absolute max value right from the get-go, because trying to lowball is just asking for trouble. You have to go into these deals expecting the unexpected. Last-minute auctions, shifting timelines, certainty is a thing of the past. So, as we wrap this up, there's really only one question left to ask yourself. Whether you're a creditor trying to get paid, an owner trying to protect yourself, or a buyer trying to score a deal, this new world of receivership sales demands a totally different strategy. So are you prepared for it? Look, this landscape is obviously more complicated and more unpredictable than ever, and trying to navigate it on your own requires some serious expertise. If you're facing any of these issues and you need some expert guidance to figure out your options and protect your interest in this new reality, the team at Iris Smith, Trustee, and Receiver Inc. lives and breathes this stuff. They specialize in these exact situations. It's definitely worth reaching out to see how they can help you navigate it all. Thanks so much for tuning in.